Analyze cases yourselves. Consider taking on a percentage of files on a work now, pay later basis. If you are approached by a law firm that you trust, not ours of course, but a good one, and you say, well, okay, we'd like to work for this victim, but they've run out of their $50,000. There's no other area that we can figure out that they should get money from. But God, I feel badly for Sue or Ed. Too bad. Well, if you know the law firm that's representing them, if you have a frank discussion with the lawyer involved and say, how good is the tort case? Is it a good case? Do you think you'll win the case? Most lawyers just don't automatically say, yeah, I win every case, although I think we do. But if you know and have that confidence, how about you ask the lawyer, look, your client needs treatment. I don't want to provide any more treatment right now unless I'm pretty sure I'm going to get paid. Can you provide me with a document signed by you and the family confirming that you will pay my account, whatever it is, at the end of the day, out of tort funds? Okay? Well, roughly statistically, in cases that our firm advances, and I suspect a lot of tort firms that they advance, over 95% of those cases are successful. I think our statistic is probably closer to 99 or 98, and I'm not exaggerating. But what that means to me is if you had a piece of paper in your file saying, yeah, we did this work over the last 2 years, and yeah, we're hoping to get paid, if you thought you had a 98% chance of getting paid, I would have thought if you didn't have enough work to do, you might say, well, actually, that's a good way to work. I'm okay getting paid in a couple of years if I know I'm going to get paid or the chances are quite high. I think it goes even a little bit further than that. Consider the possibility that when you do work for a victim, as most of you do for people under the accident benefit system, you're stuck with accident benefit rates. You get paid what the schedule says. If I'm paying you or you're working independently, somebody walked into your office, to your clinic, got referred to you for treatment, I don't think you'd quote an accident benefit rate as being your preferred rate of pay. You might actually say, actually, we normally get paid a little more from the real world as opposed to what the accident benefits people say. There's no reason for you not to charge market rates when you're working on the basis that it's not covered by accident benefits. Because in the tort action, when it gets to trial, the judge or the jury aren't told that your OT or your physiotherapist or your other specialist, your rehab therapist, aren't supposed to only get paid what SAB says. They're supposed to get paid market rates. So if you could actually charge a higher rate than what you get under SABs, even though you might get paid a couple of years down the road, you might actually work out getting better paid under that system than you do by accepting a retainer under a SABs case. I know everybody wants to get paid as they work, but I'm just suggesting to you as treatment providers, those of you in the room, that you think about this other option because I actually think you'll probably make more money in the long run. I don't think that there's anything untoward in increasing your normal rates by 10% in a case where you're going to get paid later. And do I have time to talk about funding or not?
We're running a little over time, but
I don't think it matters to most of you anyway, honestly.
No, but really, that's what our topic is. Where's the funding? So please go ahead.
Okay. The one last opportunity I think that exists is under the area of financing. There are several financing companies that work in Canada, and particularly in Ontario and obviously Toronto, funding plaintiffs or plaintiffs' counsel, including treatment in areas where there isn't sufficient money to pay under the accident benefits, and they'll get paid later. Bridgepoint Finance is the one that we most frequently are in contact with. They run a very good business. They come in and look at each file independently. They decide if it looks like a winning case, and they'll agree to advance funds for whatever purposes seem appropriate to a victim. The problem is the interest rate. The interest rate that they typically charge is between 22 and 25% annually, compounded. Our normal advice to clients is, go steal the money before you have to borrow, okay? It's cheaper for you to steal, especially if you don't get caught, than it is to borrow from these people. And it's not that I don't understand their business. They need to charge that kind of a premium in order to get paid. What's happened across Canada the last few years is that there have been a number of lawsuits attempting to get the interest payment on those types of loans included as an extra damage item from a court. In other words, you injured this victim, they exhausted all their other available benefits, they had no choice but to continue their treatment, get appropriate housing, do this, do that, feed their family. What a silly concept. So they had to borrow money. And because they had to borrow money, this was the only available interest rate that they could get. And because of that, the defendant should have to pay that interest. So far, with I think one exception, the courts have refused that. I did examine, along with Melissa, the cases that have come out under those headings, and I can tell you that most of the cases are decided on not as clear-cut a test as should you get the money or shouldn't. There have been a lot of factors in the cases that have said no that I think are wrong. For example, they didn't put the defendants on notice that there was this issue. They didn't ask for an advance payment. The lawyer used the money to fund their disbursements in the legal file, not to provide treatment. I think if you set the case up properly, that is by sending the defense insurer and their lawyer a letter saying, my client needs money for treatment. She has no access to any other funds. We need an advance payment. You've refused. We have no option except to go out and seek funding. This company's the only one that'll give us the money. Here's a copy of their interest rate terms. We will be looking to you to pay this money at the end of the case. Everybody knows what's going on now. It's very difficult for the defendant at the end of the case when they lose. And what was that stat? 99%. When they lose the case, to then say to the court, well, we shouldn't have to pay that. Just because Ed or Sue needed that treatment, don't make us pay. And the judge is going to say, well, you did have to pay. Why didn't you give them some money? It would have been the humane thing to do. Maybe there's an issue of bad faith that we have to seek here. Maybe because of that issue, the insurer is in bad faith for not putting the funding forward. Maybe the judge will award a penalty that'll happen to equal the interest payment. Maybe not. I'm not good enough to tell you I'm going to win that case or lose that case, but I know I and my partners and other lawyers in our office, we're good enough to try to make that case. So we will try to make that case in the appropriate situation, and we will try to have the insurer pay the extra penalty for refusing to fund, and we will try to have the judge find them in bad faith. I'm not good enough to tell you whether we win it or lose it. I'm just good enough to tell you that we have a chance at that. So that's one final option. Okay. That's about all I have to say. Thank you.
Thank you, Jim. We've got